Jessica
Good
Blanche.
morning, Your Honor. Christopher Shemke, appearing on behalf of my client, consenting to the matter being heard via Zoom.
Jessica Blanche, appearing on behalf of people.
And good morning, Your Honor. Rita Young, P44626, also appearing on behalf of Mr. Sean Caldwell, who is present by Zoom. Mr. Caldwell, could you state your full name for the judge, please?
Did he state his name? I'm sorry, I didn't hear.
Yes, I'm Sean Caldwell. I'm sorry, I didn't.
Okay, now here. Thank you, sir. All right, what are we doing on his cases?
Judge, as to my case, go ahead, Mr. Shimke.
On my case, Judge, the 23FB1202FY, I am now in receipt of full discovery. I would like to have a 1-week adjournment on that case so I could meet with my client. I'm also representing him on another misdemeanor case that I'd like to review with him. So I'm asking for a 1-week adjournment.
And Your Honor, as to my case, I would ask that it be rescheduled for an in-person preliminary examination, please.
Can I actually, Your Honor, real quick, can I not have this lawyer anymore? She actually left me hanging and didn't answer me and left me up running around. It's probably the reason I'm in this mess right now.
Are you referring to me, Mr. Caldwell?
Yes, 100%.
Sir,
So Miss Young is the reason you're in this mess?
Yes.
I don't think so. I'm just thinking, I don't think she was there. She's not listed as a witness. But go ahead.
Just for the record, I was appointed to represent him on January 9th of 2023. I got discovery on January 10th of 2023. I visited him at the jail on January 11th of 2023. We held the probable cause conference on January 12th of 2023, and it was set for a preliminary examination on January 24th. And unfortunately, Mr. Caldwell failed to appear, and a capias was issued. And that is why I am appearing now today.
Right out of the gate, this case reveals a pattern that Judge Simpson has seen countless times before. A defendant who believes someone else should be carrying the blame. The problem is that the court record is already painting a very different picture. What we just heard was a detailed timeline from defense counsel showing appointment, discovery, a jail visit, a probable cause conference, and a scheduled preliminary examination. That's not neglect. That's documented participation. And in court, documentation beats accusations every single time. Notice what's happening here. Mr. Caldwell is attempting to frame the situation as though his attorney somehow abandoned him. But the court is now hearing dates, actions, and events that directly contradict that narrative. When a judge hears a complaint, the next question is always simple. What does the record show? And so far, the record is not helping Mr. Caldwell. This is where many defendants make a costly mistake. Instead of addressing the reason they're standing before the court, they start pointing fingers at everyone around them. Judges tend to have very little patience for that strategy, especially when the paperwork tells a different story. The tension is already building, and if this continues, there's a good chance Judge Simpson is about to deliver a reality check that Mr. Caldwell won't enjoy hearing.
Oh, well, that really sounds like you left him hanging.
If that's the way that it is.
Sounds like you were the one that didn't show up for the date, Mr. Caldwell. All right,
I was there. The other person.
Here's what I'm going to do.
What?
Here's what I'm going to do. Mr. Caldwell,
Yeah.
I think you got to stop blaming people for what happened. You didn't appear, and now all of a sudden you're here. You got another case that Mr. Shemke's representing you on, and representing you on that. I suggest that you probably not cast aspersions at Miss Young, who can probably help you out and was, I'm sure, here ready to go.
Actually, Your Honor, at this time, I would move to withdraw and ask the court in Mr. Caldwell's best interest to assign my case to Mr. Christopher Shimke so that they can be handled together, please.
There we go.
That motion is denied. I'll take it in writing, but I'm not going to do that. I'm not going to have somebody come in to make disparaging remarks so they can try to pick the attorney that they want. Both of you are fine attorneys. You guys can work well together. Sometimes if they just be quiet and just listen to what you guys have to say, you're good. But I guess he's leaving. Okay. So he just didn't want to stick around for it all. So, Mr. Shemke, you want, a week out?
That's all I need, Judge. I will do an in-person meeting and then reach out to Ms. Blanche so we have an informed decision by our next court date. Yes, please.
All right. I'll adjourn your probable cause out a week. We'll see if we can get him to stay in the room.
Nathan Taylor now?
At 9. And then you wanted a preliminary examination, Ms. Young. So I'll set your preliminary examination in that matter for the 13th. 2023 at 9 before, that'd be before Judge Washington. That ought to be fun. All right, before Judge Washington. And what we'll do is we'll have his bond continued. That way he'll be there.
By this point, Judge Simpson has effectively shut down the blame game and moved the case back onto the rails. That's an important judicial function that often gets overlooked. Courts are not designed to host endless arguments about personal grievances. They're designed to move cases forward. Look at what happened. Mr. Caldwell attempted to shift responsibility toward his attorney. The attorney then laid out a detailed timeline. Judge Simpson reviewed the situation and reached a straightforward conclusion. The missed appearance was the defendant's responsibility. From there, the court pivoted immediately into scheduling and case management. And that's actually a bigger moment than it appears. Judges pay close attention to accountability. When someone repeatedly refuses to acknowledge their own role in a problem, it affects credibility. Credibility is one of the most valuable currencies a person can have in a courtroom. Lose it, and every future argument becomes harder to sell.
Yes, Your Honor. 2104557-301.
And that's the people of the state of Michigan versus Sherrion Williams. I believe the defendant is charged with one count of trespass. Oh, here's the docket. Yes, okay. Yes, she's charged with one count of trespass and she was scheduled for arraignment yesterday. Appearances, please.
Judge, for the record, Christina Ritter on behalf of the people. However, Judge, I tried to pull up this case in my system. I believe this may be an AG case because I can't find it.
Oh, okay. Mr. Flanagan, does it say where the alleged offense took place?
Motor City Casino.
Okay, yeah, this is an AG case. All right, Ms. Stevenson.
Janice Stevenson appearing on behalf of Ms. Sherrion Williams. Ms. Williams, ma'am, please, when you're able to do so, unmute and tell the judge your full name.
Sherrion Denise Williams.
All right, today is a date set for an arraignment, and this is an Attorney General's case. Ms. Stevenson.
Stands mute, waives the reading of the information, asked to the plea of not guilty. Enter on her behalf and the matter be set for pretrial conference.
The court is going to enter a not guilty plea. Set the matter for pretrial conference, June the 28th.
Just like that, we move into an entirely different case and a completely different atmosphere. The contrast couldn't be more dramatic. Gone is the confrontation from the Caldwell matter. Now the court is handling an arraignment involving Miss Williams, and the focus immediately shifts to procedure. An arraignment is one of the foundational stages of a criminal case. The court ensures the defendant understands the charge, enters a plea, and establishes the next court date. In this instance, a not guilty plea is entered and the matter is scheduled for a future pretrial conference. It may sound routine, but these moments matter because they formally launch the next phase of litigation. What's interesting here is that defense counsel quickly turns the conversation toward bond. That's where things become important. A bond decision isn't simply about release. It's about balancing public safety, court appearance requirements, and the defendant's circumstances. The defense is already signaling that there may be reasons Miss Williams should not remain incarcerated.
At 8:25. As to bond.
Your Honor, I'm asking for personal bond. I would ask Mr. Flanagan to help me. I don't know why Ms. Williams is over at the Wayne County Jail. I didn't see anything. The only thing I could see for her is that she has a matter at 36th District Court pending. I think for September in front of Judge Taylor, but I don't see anything that she has open over. I don't see any felonies that would be pending. I don't know why she's at the county. So I would ask for personal bond. No contact with the casinos, Your Honor.
Mr. Flanagan, do you have any information outside of what Ms. Stevenson just said?
No, Your Honor. All of the other cases appear to be closed in our court.
All right. Miss Williams, where's the deputy?
corporal cuff is, I'm about to knock on the door right now. And I wanted to say to you, Your Honor, I hope you had a wonderful vacation.
How you know about my vacation? Everybody know about my vacation?
Yeah, I just hope you had a good one and you ate good.
I did. But you wasn't on course, so how you know about that I was on vacation? Somebody told you?
Well, just like the street talk, Wayne County Jail talk to you.
My vacation in the Wayne County Jail?
And suddenly this hearing takes a turn nobody expected. What started as a routine bond discussion has somehow transformed into a conversation about Judge Simpson's vacation. The most surprising part isn't that Ms. Williams knows about it, it's that she appears completely confident discussing it. According to her, word of the judge's absence had apparently made its way through the Wayne County Jail. Now that's a sentence you don't hear every day. The exchange is funny, but it also highlights something deeper. Courtrooms are often viewed as isolated environments, yet information travels remarkably fast through detention facilities. Inmates talk, rumors spread, stories evolve. Apparently, this particular vacation became notable enough to become jailhouse conversation. Judge Simpson's reaction is priceless because he's genuinely trying to figure out how his travel plans became public knowledge among people currently incarcerated. Meanwhile, Miss Williams delivers the explanation with complete certainty. People talk.
Yeah.
That's a mess. That's a mess. That's a mess. They said the judge on vacation. If you want to go to court, go. Hurry up and get there this week.
What she want to do?
They said to hurry up and get there this week. Good morning. Good morning, Corporal. Miss Williams was just telling me about how they was talking about my vacation in the jail. Corporal, why is Miss Williams in jail? Does she have another case pending or something?
I believe this was the last matter that we had to have paperwork on, Your Honor. Let me double check the computer.
Okay. But she had some other cases when she first came into the jail?
Yes, she had several cases when she first came in.
Yeah. Mm-hmm. And this is the last man standing?
I do believe this is the last matter standing.
Okay. All right. Well then, okay. You can take.
Yes, I have time served on every other matter.
Oh, okay. How long has she been there?
She has been in here since 3/9 of this year, Your Honor.
Okay, since March 9th. All right. Okay, you can take it back. Thanks. Okay, Miss Williams, I'm going to give you a personal bond, but are you going to come to court?
Yeah, I'm going to come see you June 28th.
Okay.
This is where the hearing becomes much more significant than a simple scheduling matter. Judge Simpson is now evaluating whether Ms. Williams can be trusted to return to court if released. That's the central question behind many bond decisions. Notice how the judge isn't only asking legal questions. He's asking practical questions. Does she have somewhere to stay? Does she understand the court date? Is she willing to appear? These details help the court assess reliability and stability. What stands out here is Miss Williams' attitude. Instead of hesitation, she's giving direct answers and expressing confidence that she will return. In fact, she seems almost enthusiastic about seeing the judge again at the next hearing. That level of cooperation often works in a defendant's favor because judges are constantly evaluating demeanor alongside the official record. There's also an important legal takeaway. The court is not eliminating obligations. Miss Williams still faces conditions. She still must appear. She still must comply with court orders. Release is not the same thing as dismissal. Many viewers confuse those concepts, but they're very different. The real question now becomes whether Judge Simpson believes her promises are credible enough to justify a personal bond and an opportunity to get back into the community.
And do you have somewhere to live? Where you living these days?
Well, I'm actually going to the Salvation Army because they would help me with housing.
Okay, that's a good idea. But you're gonna come to court either in person or on Zoom on June 28th, okay?
Well, I would rather come in person just to see you personally.
Okay, well then I'm gonna come in person too. I'm gonna write it down on my book. Oh, we'll be in trial anyway. Let me see. Okay, but I'm gonna write it down. Come in person to see Miss Sherian. Come in person. All right, so come in person.
Yeah.
And then I'm gonna be in person too, okay?
Okay, okay,
Okay,
and
so
I'll see you June 28th.
June 28th. So I'm gonna put her bond at $500 personal bond. No contact with the casinos. You can't go to the casinos, Miss Williams, while this case is pending, okay?
Okay.
All right. I'll see you on the 28th. You have a great day. Stay safe. They should be releasing you shortly.
Yeah, actually, they're gonna release me, I think, after dinner, because that's when all the paperwork come, like when the court's closed.
Okay. I want you to stay away from jail so you won't know the procedure. Okay.
Oh, well, actually, I turned 50 in jail, so I'm
Did you?
done.
You had a birthday while you was in jail?
Yeah, my birthday was March 11th.
Did they give you a birthday cake?
No.
Oh, they so disrespectful.
Right, but it's all good.
All right. Well, happy belated birthday, Miss Williams. And I'll see you on June 28th. Maybe we can remember to get you a cupcake.
Okay, thank you. God bless you.
You as well.
Okay.
All right. Bye-bye.
What a remarkable contrast to the hostility we saw earlier in the video. The conversation has evolved from a bond hearing into a surprisingly human interaction. Miss Williams reveals that she spent her 50th birthday in jail, and Judge Simpson responds with a mixture of humor and empathy. The joke about a birthday cake, and later a cupcake, is lighthearted, but it carries a deeper message. Judges spend most of their days dealing with criminal allegations, missed court appearances, probation violations, and difficult circumstances. Yet moments like this remind everyone that defendants are still people. Behind every case number is a person with a story, a family, and experiences that extend beyond the courtroom. At the same time, it's important not to confuse kindness with favoritism. The judge isn't changing the law. He isn't dismissing charges. He isn't giving special treatment. He's simply recognizing a human moment while still enforcing the legal process. Do you think moments like this help improve public confidence in the justice system? Or should judges remain strictly formal at all times? It's an interesting question because exchanges like these often reveal a side of courtroom proceedings that television dramas rarely show. One thing is certain, Miss Williams is leaving this hearing in a much better position than when it began.
Oops, I didn't mean to put her in the in the waiting room. Maybe do the cupcake have to come from the prosecutor so I won't be accused of being favoritism or something? Okay. All right. I'm ready for Lopez to come on screen. He can go to the wait.
Mr. Tinsley, please state your name for the record.
Carl Richard Tinsley.
All right, what are we doing?
Your Honor, today is the date and time set for the probable cause conference. At this time, Mr. Tinsley would respectfully request that these matters be set for preliminary examination at the earliest possible date.
Your Honor, I'd like to address the court too, if there's a moment.
Well, all right, preliminary examination in person, June 13th, 2023, 9 a.m. That's before Judge Burke on all the matters.
So what was that date again, Your Honor?
June 13th.
Thank you.
All right.
Yeah, I have a couple of things, a couple of concerns, Your Honor, about just the way things are proceeding. I've been in jail 5 months now. And despite being here 5 months, I'm not aware of all of my charges, despite asking public defender to bring me some kind of documentation or something to explain to me everything that is why I'm in jail. I've also recently, as you know, gotten honest about some things that have been going on with me mental health wise for the last 25 years that I've undisclosed, that I haven't told anybody about. there's been some tests ordered, right? So we've done one part of a two-part examination.
Now we enter a very different type of hearing, one centered on mental health evaluations, competency issues, and a defendant struggling to understand a complicated legal process. Mr. Tinsley is expressing frustration that many defendants experience when criminal proceedings intersect with psychological evaluations. From his perspective, there appears to be confusion regarding what examinations have been completed, what findings have been made, and what happens next. Competency and criminal responsibility are related concepts, but they're not the same thing. Competency focuses on whether someone can understand proceedings and assist in their defense. Criminal responsibility deals with legal accountability for conduct. Those distinctions matter tremendously because they can affect how a case proceeds through the system. Listening to Mr. Tinsley, it's clear that uncertainty is creating significant distress. He repeatedly emphasizes confusion, communication concerns, and a desire to understand exactly where things stand. Whether or not every concern is legally justified, the frustration itself appears genuine. The challenge for the court is balancing those concerns with procedural realities. Judges must ensure fairness while preventing hearings from becoming endless debates over issues that are better addressed through counsel. That balancing act is about to become the central focus of this exchange.
The first part, which everyone in the court is aware of, was the competency. The second part was the responsibility. I have not done the responsibility portion. We know that the competency portion I was found competent. Yesterday, my attorney met with me and we were trying to discuss ways to move forward, and I was expressing my concerns at being confused at not knowing what the next step was. It was explained to me by the forensic center doctors that the responsibility portion was going to be the next step in this process, right? And my public defender yesterday was asking me how I wanted to move forward, whether I wanted to move forward with preliminary examination or not. This caused me a lot of distress because I was unsure of the process, right? Moving along, my public defender had assumed that the report found me responsible and competent, and the report had not found me competent and responsible. I don't know what this does with regards to time delays, with regards to how this is going to work in the next court. There's a lot of trust issues that I'm having right now, a lot of distress regards to this process, a lot of feelings of just going through the motions versus just being represented. And it's extremely distressing. Now, my attorney did come back yesterday and say, hey, I assumed that the report found you competent and responsible, but it did not. But again, it just further adds to my distress because you individuals are the professionals. You do this every day.
This section highlights one of the most difficult dynamics in criminal court: trust. Mr. Tinsley is describing a situation where he feels uncertain about the information being communicated to him. From his perspective, misunderstandings regarding reports and evaluations are reinforcing broader concerns about the process itself. Whether those perceptions are accurate or not, they are clearly influencing how he views his representation. The defense attorney, however, is presenting a very different picture. Counsel is explaining meetings, discussions, future jail visits, and plans to review reports and charges in detail. That's an important distinction because courts often evaluate not only complaints but also the documented efforts being made to address those complaints. What we're watching is a collision between subjective experience and objective procedure. One side feels confused and distressed. The other side insists explanations have already been provided and more discussions are forthcoming. These situations are challenging because frustration can become self-reinforcing. The more confused someone feels, the more likely they are to interpret additional information through that lens. The court's goal is to break that cycle by ensuring communication continues while keeping the case moving forward. Judge Simpson has been listening carefully, but he's also reaching the point where patience may start giving way to a more direct response.
This is, and for a significant thing, I'm going through significant issues here where I'm disclosing self-harming mental health behaviors that I have never told people about in nearly 30 years.
And this is having such, I'm trying to manage that. And I'm trying to get an understanding, wanting to understand what it is that I'm accused of versus wanting to deny responsibility if that makes sense. I'm not necessarily trying to dispute anything. I'm just trying to understand what it is that exactly I'm being charged with and why.
Okay, so Mr. Tinsley, let me go ahead and cut you off right here. For the record, Mr. Tinsley is correct. We had several conversations yesterday, 2 separate jail visits, 3 phone calls. I made it clear to him that I would be down to visit him with the discovery and to go over these things. I made it clear to him once I showed him the report that the criminal responsibility is not the bailiwick of the district court. It is the circuit court's bailiwick. All of these things have been explained to Mr. Tinsley. Mr. Tinsley may have some ask that he's going to make. I don't know what that's going to be, but let me reiterate for the record and to Mr. Tinsley, I will be down to see you. I will bring the police report. We will go over each of the counts and the charges. So if there's something specific that you'd like to ask the court that you don't think your counsel can respond to in our meeting, then go ahead and make that specific request. Other than that, I would advise against you talking too much about your case on the record at this time. Do you understand what I'm saying to you?
I understand fully what you're saying. And that has been a large part of my issue, is trying to sweep things under the rugs for fear of who's aware, who knows, and trying to kid myself with regards to what is really going on. That is why this has been—
Mr. Tinsley.
Yes.
At this stage, the tension has become unmistakable. Judge Simpson, defense counsel, and Mr. Tinsley are all discussing the same process, yet they appear to be viewing it through entirely different lenses. Mr. Tinsley continues emphasizing confusion and concern. Counsel continues emphasizing communication and explanation. The judge is trying to determine whether this is truly a breakdown in representation or simply frustration with an inherently stressful process. One thing courts frequently encounter is the belief that disagreement automatically means ineffective representation. Those are not the same thing. A defendant may dislike advice, disagree with strategy, or remain frustrated while still receiving competent legal representation. Judge Simpson has known this attorney for years, and that history matters. Judges develop professional observations based on thousands of courtroom interactions. When assessing claims about counsel, they inevitably consider those experiences. What do you think? If a defendant genuinely feels confused, but the attorney has repeatedly met, explained, and offered additional review sessions, where should responsibility ultimately fall? On the attorney for finding another way to communicate, or on the defendant for continuing to engage until understanding is achieved? That question sits at the heart of what happens next.
We've been dealing with each other for a number of years. And one of the things that happens with you, and I get the frustration at the process, and you might have to ask somebody what specifically is going on. You might have to do that 2 or 3 times before you can absorb it.
I tried to do that last court date. I was stopped and said, your attorney will be to visit you. And he was to visit me yesterday. And nothing, and I'm sorry for interrupting, Your Honor. I really apologize to the court and for taking up this time, but Mr. Brown, he's been doing this for a long time. And I just feel like this is just I'm just going through the motions. That's just going through the motions. And I'm sorry.
Just going to, then Mr. Tinsley, I'm going to stop you, and I'm not even going to listen anymore, because I'm going to tell you what, you're right. Mr. Brown's been doing this a long time, and I've watched him do it for a long time. And he's not a guy that just goes through the motions, just plain and simple. So if you think that's what he's doing, you're wrong, because he's trying to explain something to you. He's trying to work through your case. He's trying to do everything in his power to try to either resolve it or move the case forward. So if you're here to tell me that you feel like he's sending you through the motions, I'm not even listening, because that's not true.
But he didn't read the report.
I am done.
Didn't read the report.
I'm done.
Yes, sir.
Bond continued.
And with that, Judge Simpson brings the matter to a close in unmistakably direct fashion. Throughout this doubleheader, we witnessed two completely different courtroom dynamics. In the Caldwell case, the central issue was accountability. Judge Simpson rejected attempts to shift blame and focused on the documented record, ultimately keeping the case moving through scheduling and procedural orders. The message was clear: personal responsibility matters. In the Williams case, the atmosphere shifted dramatically. What began as a routine arraignment evolved into a memorable discussion involving jailhouse gossip, vacations, bond considerations, and even a belated birthday celebration. Despite the humor, the legal outcome remained important. Judge Simpson entered a not guilty plea, scheduled future proceedings, and granted a $500 personal bond with conditions, including no casino contact while the case remains pending. Finally, in the Tinsley matter, we saw a defendant struggling with confusion surrounding competency evaluations, criminal responsibility issues, and communication with counsel. After hearing both sides, Judge Simpson firmly defended the attorney's efforts, rejected the suggestion that counsel was merely going through the motions, and continued the bond. The overarching lesson from all three segments is simple. Courts rely on facts, records, and accountability, not assumptions, frustration, or finger-pointing. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.